Hi, Andy Nelson. Today I want to talk about a seventh way that you can torpedo your trademark rights. That is simply failing to use your actual marks in commerce. Now, in order to have trademark rights in something, a word, a symbol, a logo, right, a slogan, or something else that's distinctive, it has to be a trademark, not just an idea. It has to be a trademark, which means you are using it in connection with goods or services in commerce, right? And then consumers see the mark, they associate the mark with a single source of goods or services. So, hey, by definition, it has to have a certain kind of use. So a lot of folks, they come at me and say, oh, I've got this great idea. This is mine. I thought of this last year, but I just saw somebody using it. Can I sue them? Well, have you used it? No, but I thought of it first. That's not going to work, right? You've got to actually, it's not a trademark. It's an idea at that point. To be a trademark, it has to be used in commerce. So used in connection with goods or services to identify goods or services and distinguish one source from those of a competitor. If it doesn't do that, there are no rights in it at all. Nothing. Zippo. So that's how you can torpedo your ideas or your mark by not actually using it as a mark. One exception, if you set your sights on using something, you thought of the perfect logo or name or whatever other distinctive thing that's going to function as a trademark in connection with your services or your goods that you're going to use in the future, you can actually put your foot in the door, so to speak, if you're eligible otherwise, by applying for a federal registration on what's called an intent to use basis, or I keep saying foot in the door, reservation, whatever you want to say. Even though you haven't used it yet, there is that one exception where you can apply and say, hey, I'm going to be using this. Here's my date of application that gives me priority over those who would actually use it in commerce subsequent to you, so long as you eventually, on a certain timeline, use your mark in commerce with goods or services. So there is a limited exception if you follow certain steps in order to reserve something and actually have rights over someone else, and you don't have to use it in commerce until later. But all things being equal, you cannot have trademark rights unless you use use the mark in commerce correctly, and that in and of itself will help preserve, build rights, and give you hopefully priority over others who may come after you. Now there's more to that. There's more to that issue, but generally speaking, that's the way to do it. You don't do that if you just have your mark in your head and you tell people about it. Even if you don't tell people about it, if other people come up with the same or something similar, they're likely going to have priority over you. So that will torpedo your plans. So don't do that. Anyway, that's it for this video. If you have any questions about contents of this video, drop a note or drop a comment. Shoot me a note. If someone would benefit from the contents here, please feel free to share it. Until the next one, have a good one.